Good day, future lawyers. This is the 2019 amendments to the rules on evidence, particularly on the original document rule, previously known as the best evidence rule. The 2019 revised rules on evidence was approved by the Supreme Court en banc on October 8, 2019 and became effective on May 1, 2020. What are the significant changes? The amendments to the revised rules on evidence reflect various Supreme Court rulings on admissibility and evaluation of evidence. The introduction and appreciation of electronic evidence were also further refined. Significant amendments include provisions implementing the Apostille Convention to which the country is a party. The erstwhile best evidence rule is now known as the original document rule in order to avoid confusion since the rule only applies to documents. Documentary evidence now includes recordings, photographs, words, sounds, numbers, or their equivalent. Privileged communications were expanded with respect to attorney-client and physician-patient relationships. Persons reasonably believed to be attorneys and persons assisting the attorneys are now covered by the disqualification. Exceptions to the attorney-client privilege are now included, such as if the services or advice of lawyers are sought or obtained in furtherance of crime or fraud, and communications relevant to issues among claimants through the same deceased client and those concerning a breach of duty by the lawyer or client, documents attested by the lawyer and joint clients. Aside from physicians, medical practitioners now include psychotherapists and those persons reasonably believed by the client to be authorized to practice medicine. The privilege extends to confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition. There is likewise a new provision on communications obtained by third persons, which remain privileged provided that the original parties took reasonable precaution to protect its confidentiality. Hearsay is now defined and differentiated from the rule requiring first-hand knowledge. Some exceptions to the hearsay rule were modified. The dead man statute was done away with, and the testimony of the survivor as well as hearsay evidence of the deceased may now be admitted. Acts, declarations, and traditions about pedigree now cover family relations through adoption. Records of regularly conducted business activities as exceptions to the hearsay rule no longer require for the entrant to be dead or unable to testify and covers written and electronic documents as well. A catch-all provision known as residual exception was added to cover other statements having equivalent circumstantial guarantees of trustworthiness as those enumerated, subject to certain conditions. There is now a clear distinction between burden of proof and burden of evidence. Witnesses may be impeached by evidence of conviction of a crime only if such was punishable by a penalty in excess of 1 year or if the crime involved moral turpitude, regardless of the penalty. All evidence must now be offered orally. The offer of the testimony of a witness must be made at the time the witness is called to testify, while the offer of documentary and object evidence must be made after the presentation of a party's testimonial evidence. Objections to the offer of evidence must likewise be made orally. Immediately after the offer is made, objections to the testimony of a witness for lack of a formal offer must be made as soon as the witness begins to testify. So here are the 2019 amendments to the 1989 revised rules on evidence. Section 1. Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 3. Admissibility of evidence. Evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. Rule 130. Rules of admissibility. Letter B. Documentary evidence. Section 2. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, store images, X-ray films, motion pictures, or videos. Original Document Rule. Section 3. Original document must be produced. Exceptions. When the subject of the inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offeror. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only a general result of the whole. D. When the original is a public record in the custody of a public officer or is recorded in a public office, and E. When the original is not closely related to a controlling issue. Section 4. Original of document. Letter A. An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. Duplicate. A duplicate is a counterpart produced by the same impression as the original, or from the same matrix, or by the means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, or by chemical reproductions, or by other equivalent techniques which accurately reproduce the original. A duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as to the authenticity of the original, or 2. In the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. Section 5. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution and existence and the cause of its unavailability without bad faith on his or her part, may prove its contents by a copy or by recital of its contents in some authentic document or by the testimony of witnesses in the order stated. Section 6. When original document is in adverse party's custody or control. If the document is in the custody or under the control of the adverse party, he or she must have reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he or she fails to produce the document, secondary evidence may be presented as in the case of its loss. Section 7. Summaries. When the contents of documents, records, photographs, or numerous accounts are voluminous and cannot be examined in court without great loss of time, and the fact sought to be established is only the general result of the whole, the contents of such evidence may be presented in the form of a chart, summary, or calculation. The originals shall be available for examination or copying or both by the adverse party at a reasonable time and place. The court may order that they may be produced in court. And we're done. So note that the 2019 amendments expanded the definition of documentary evidence. Original document rule is a rule on admissibility or competence. This rule superseded the best evidence rule. Thank you for watching.